Okay, thanks everybody for coming to join me on this quarantined Tuesday in March of 2020. I'm assuming everybody can hear me. I've got Andrew and the team at the NSBA in the background. They are monitoring everything, and they will be monitoring your questions. So please feel free, as we're going through this, to stop me and ask questions. We're going to ask that you do that in one of two ways. Either type in your question and enter it, and I'll get a flag that a question's come up, or use the raise your hand button. You can find it on your menu screen, and if you raise your hand, then the team at the NSBA can unmute you and you can ask it and I will answer it. Whether it's written questions or or a raise your hand question or an oral question, I'll answer them live. If you've got more questions after this seminar, I'm available to answer them. So what I'm here to talk about today is COVID-19 and really the impact on employers and some of the changes that the province has made and the feds have made to help employers try and navigate through this. Now, it's a moving target. Things change from day to day, and we actually have a website or a page on our website up with the updates that we've done. And I know some of you have received them already, some of you have not. But the page, the website is seiferlinglaw.com/COVID-19. You're able to find it on there. Today, what I wanted to go through, I'm just going to walk through a few things. And like I said, stop me at any point if you've got questions. The main timelines that we're looking at here, as far as the COVID stuff goes, with respect to the government of Saskatchewan making changes. On March 17th of this year, the government made some changes to the Saskatchewan Employment Act. On March 18th, they declared the state of emergency. And on March 20th, they made some changes to the employment standards regulations. So we have those three dates are the relevant ones. And I'm going to talk a little bit right away about what that means. Things are still evolving daily. We're hearing about new programs daily. We're hearing about different issues. There are a number of issues that come up, and everybody's business is going to be affected differently. We see some businesses right now that are actually, their business is up, and as a result of being in that supply chain for the essential services, and so they're dealing with very different issues. Like refusals to come to work, than some of the businesses who are negatively affected by COVID. And most of the businesses right now are negatively affected in some way. I'm going to walk through some of the stuff for employers. I'll talk a little bit about some of the other issues that have come up, but beyond employment law, employment and labor law is where my expertise lies. So I am going to avoid delving into areas beyond that, other than to mention some of the issues that have been flagged. So the two big changes that our government, the government of Saskatchewan, has made, the first one was the one that they made on the 17th, and that's to create something that they call public health leave. Now, public health leave is available in one of two conditions. The one that we believe is satisfied right now is that there is a global state of emergency. So the WHO declared a global pandemic on March 11th, and the state of emergency has been accepted in Saskatchewan which occurred on March 18th. So based on that, we have one of the two triggers for the public health leave. Public health leave, unlike a layoff, this is just a leave. And the position that we're taking is that it would be a sickness or an illness leave. And what public health leave is it is the power of government, a medical practitioner, the chief medical health officer of the province, or most importantly for us, employers, to send workers home to self-isolate. Now, there's a number of situations where this could occur. The government's perspective, at least some departments of the government are taking the perspective that this public health leave is fairly narrow, that it only applies to businesses that have been ordered to close down by government in whole or in part, which would include the fitness industry, which would include restaurants, dine-in for restaurants, which would include any of the big assembly places like casinos, bingo halls, theaters, any of those types of places. That's at least Employment Standards Saskatchewan has said that that's where the public health leave applies, but the government has specifically given employers the ability to send their employees home. That ability to send employees home is kind of rendered meaningless if it's only by order of government. So we believe that the public health leave is available, maybe not as broadly available as layoff, which is the other thing I'll talk about, but it is available. It is available to the general public, to employers, and it is a mechanism by which you can send your employees home to self-isolate. Now, if you send them home and you authorize them to work from home, which we strongly encourage you to do if it's at all possible for your business and for the role they're playing, if you send them home and you authorize them to work from home, they're paid their regular wages. That's what the law says. They're paid their regular wages to work from home. What that means is largely dependent on the position. So if they are a salaried employee, you continue to pay their salary. If they are an hourly employee, you pay them for the hours they work. Now, tracking hours and all that stuff does get a little bit complicated, but if you send them home and you authorize them to work, you have to know that you are going to be required to pay. And like I said, we do encourage you to use that tool and allow people to work from home where it's possible. We want to have as little disruption as possible to the economy, and while at the same time recognizing that this is a significant downturn for a number of businesses. And this is likely to last, the actual state of emergency is likely to last at least 2 months, if not longer. And I think one of the big factors is that a lot of people don't realize that 2 months is a significant amount of time when it comes to adding things up. You're seeing the people starting to realize that the quarantine and the self-isolation is going to have an effect after about a week of people self-isolating. Imagine that multiplied by 8 or 12. We're going to see that, and we're going to see that having a significant effect. So that's the first one, is the public health leave. The other facet of that, before I move on to the layoff stuff, is that employees who have been affected by the closure of schools or childcare facilities are allowed to tell their employer that they are taking a public health because they need that public health leave to go care for their child. That is one of the options that is available to employees. These are unpaid unless you authorize them to work from home. Both the public health leave and the layoffs, which I will talk about next, are unpaid, and therefore you are not going to be on the hook, and it's not a severance situation. The only way that a public health leave becomes a severance situation is if you make a business decision that that position is not going to come back even at the end of the leave period, that you're going to discontinue that position, then you're in a layoff and severance position, and then you need to give the notice or pay in lieu of notice that is required to terminate that employment relationship with the employee. Last thing on the leave is it's a protected leave. So protected leave means that you are required to take the employee back. Like I just said, if you need to, if you're looking to sever them, if you're looking to get rid of them, then then you're going to need to be cognizant of what the severance requirements are, the common law severance requirements are, or the layoff requirements. I'll stop there for a second, and I'll just check to see if there's anything that's come up for questions. No, not yet. Okay, let me move on to the layoffs. So people were confused as of last Wednesday and Tuesday and Wednesday when government tabled this, passed it, the public health leave changes to the Saskatchewan Employment Act, and then on Wednesday declares a state of emergency. And then we were asking all these questions, and Employment Standards was telling us and other people that, this only applies to businesses that have been ordered to close. And so that was problematic. On Friday, what happened is they introduced changes to the regulations in Saskatchewan that created a layoff option. And normally with layoffs, you are required to pay severance, what's commonly called severance, or give notice to the employee when you're laying them off. What they did on Friday, what our government did on Friday, was they created a temporary layoff that applies while the public state of emergency is in effect, which we have as of last Wednesday. And it is for a period of 12 weeks in a 16-week period. Now, what that means is you could use rolling layoffs if your business has been affected but not completely shut down and you're still operating at a lesser capacity. The easy example would be you'd be able to say, okay, you're going to work 1 week and then take 3 weeks off on layoff, work another week, 3 weeks off on layoff. You could do that indefinitely until the end of the emergency period. As soon as government declares the end of the emergency, the state of emergency, then this layoff option no longer applies. Then you need to make a decision about whether you're going to go through a permanent layoff or another form of temporary layoff that's going to require notice and severance. But this layoff option is without pay and without notice. So you are able to do that. You could lay off all of your employees today. It's an option available to employers. You can lay off all of your employees today for a period of 12 weeks from today, as long as that state of emergency stays declared. But you would be required to take them back at the end of the 12 weeks for a 4-week period. And then if the state of emergency is still in force, you'd be able to lay them off for another 12 weeks. That's why you do have the option to do the rolling layoffs. You do not have to lay off all of your employees at the same time. You do not have to lay off your entire workforce. You don't have to take everybody back at the same time. As long as you are meeting the guidelines of 12 weeks in a 16-week period and keeping it within that, then you are not in a traditional layoff or severance position. You are not going to be required to give notice or pay in lieu of notice in the province of Saskatchewan, as long as you are following those guidelines on the layoff. So those are the general rules around around temporary layoff. The main differences between. All right. I've got a question coming in. If an employee is temporarily laid off, can the employee demand a permanent layoff, thus causing the employer to pay full severance? No, they can't. If you are if you're using this, this is a specific power during a state of emergency. Then it's a temporary layoff, and as long as you meet those 12 weeks in the 16-week period requirement, you are not required to give notice or pay in lieu of notice. Now, that being said, an employee can ask for anything, and you can agree to give it to them if you want to, but you are not required. They cannot demand it. Where the employee demands or where the obligations on the employer will come in, those would be with respect to those people who have childcare obligations, at home, and they are unable to fulfill them because of the closure of schools or daycares. That's going to be the big one right now. The other big one for employers is the 14-day quarantine period. A number of people, especially in Saskatchewan, travel around this time of year, and that 14-day quarantine period is, well, you heard the Premier last Friday. It's law. If you are not observing the 14-day quarantine period, you can be fined up to $2,000, and that can be that can have it can be fined up to $2,000, and so it is a legal obligation. Now, the only potential exception that I can think of to the 14-day quarantine period would be that if you are a frontline healthcare worker coming back from traveling and you are going to be exposed to COVID in any event based on what you're doing, then you may be required to go back to work. But even then, the 14-day period applies to everybody, and the government has not outlined any exceptions to it. Okay, a couple more questions here. If we've already authorized employees to work from home, but work dries up before the state of emergency is lifted, are we then able to lay off at the time, or do we have to continue paying full wages for the length of the state of emergency? You can, like I said before, you can enact the layoffs at any point in time for any of your employees. It can be for 1, for 10, for 100 of them. You're able to enact the layoff whenever you need to. If you've authorized them to work from home and then the work dries up, what you would say at that point is, I'm sorry, we don't have the ability to have you continue to work from home because there's nothing for you to do. We are going to use the temporary layoff powers that are created under the, I think it's section 44.2 of the Employment Standards Regulations, and we're going to lay you off for the next, and it can be up to 12 weeks, or you can do a rolling layoff, like I said before. It could be, as long as it doesn't exceed 12 weeks in that 4-month period, in the 16-week period. I guess that's not exactly 4 months, but 12 weeks in a 16-week period. So you could rotate them however you want, as long as it doesn't exceed that. Other question, how does the temporary layoff apply to part-time workers, the same as full-time employees? Yes. It applies exactly the same to part-time as full-time employees. The layoff provisions are not restrictive. They do not say that that it would be restricted to part-time or full-time. The one caution that I'd put in there is, if you're using the public health leave and you are required to pay an employee's regular wages, and you've got your hourly employees and they're going from full-time at the office to possibly part-time at home, I would probably go with the layoff provisions rather than, or at least partial layoff provisions, rather than the public health leave, because there would be a discussion, or at least an argument that could be raised on regular wages, what you would be required to pay them. Okay. All right. Here we go. If we were to lay off an employee, are we able to bring them back temporarily as an independent contractor? If you're going to lay off an employee and it's going to be anything like permanent, then you'd be on the hook for severance, and you'd be on the hook for either notice or pay in lieu of notice in that case. Because if you're going to bring them back as an independent contractor, then you are laying them off on a more permanent basis. That would be a tough one to do. If you're looking to bring them back as an independent contractor, then my recommendation would be to just keep them on as an employee and just talk to them about either a rolling layoff or a reduction in hours as you manage through COVID. I hope that answers that one. The next one, what due diligence on the part of the employer is required for returning employees to ensure that employees do not introduce a COVID safety concern for other employees? So I'm assuming you're talking about employee returning from travel. The employees returning from travel, those ones are, they are now required by the government to be quarantined for 14 days. If you have somebody who has returned to work and they should be in quarantine, as employers, you should be sending them home or preventing them from returning to work. And I know you will, with some employees, you will experience resistance, but the simple answer is that's the law in Saskatchewan right now. And if you insist on coming to or near the place of employment, then we'll have to report you to government, and they'll enforce the fine against you. That's due diligence on the part of the employers. If you know that your employee has traveled, then you enforce that 14 days. Like I said, there are no official exceptions to that. They may make one for frontline healthcare workers, but that's going to be pretty rare. If someone lays off full-time staff and brings them back to assist with online training at a significant reduction of hours, do you know if they're still eligible for EI? If you lay them off, they're eligible for EI. If you want to bring them back to assist with online training, there are a couple of programs. There's one federal program it's for small businesses, not-for-profits, and charities, where they will supplement some of your wages. That's for employers, not employees. You can also, there are ways with the sickness benefits to create a top-up plan for your employees. Just like with the earlier question, if you are going to bring them back on to assist with online training or to do anything else, I would do that even if it's on a part-time basis. I'd work that out with the employee and have them continue to be an employee rather than be laid off at that time. You can be flexible, and you can use the rolling layoffs to have them work part-time and then have them laid off part-time. And when they are laid off, they will be eligible for EI. For the COVID-related layoffs, including this temporary layoff that we're using, you can code your ROEs as illness injury. That avoids the waiting period for your employees, the 1-week waiting period, and it puts them in the queue with the processing, well, theoretically speedier processing. I'm already hearing that they're having significant lags in processing any EI applications right now. Next one, I'm assuming employee benefits can be terminated upon layoff, but want to confirm, please. Yes, you can terminate them. You can, obviously as an employer, you can continue to pay them if you want to, but there's no obligation to pay them. What I recommend doing if you want to, what I recommend doing with the employees is offer them the option to continue the benefits and to pay for it, so that they don't lose the benefits if they're willing and able to pay for it before you say it's cut off completely. But the short answer to that question is that benefits can be terminated. It's just like any other leave, and that applies for layoff or for the public health leave. I know for any of you who have dealt with maternity or parental leave, those ones, you usually have the option to keep them on or to shut them off while you're on that leave. Somebody came in a little bit late, is asking to explain the public health leave quickly again. Public health leave, I'll repeat it very quickly. The public health leave is triggered by a global declaration of state of emergency, which has been accepted in the province of Saskatchewan, which we have as of last week. And public health leave gives the employer, the government of Saskatchewan, the chief medical health officer of Saskatchewan, or a medical professional the ability to send their employees home, the employees of a business home, to self-isolate. It also gives employees the ability to say, I've lost my child care, I need to go home and take care of my child. That's the public health leave in a nutshell. It's a leave, it is not a layoff, but you still give the employees an ROE. And once again, that can be coded as illness injury. When I lay off employees and build a recall list of those employees, is there any issue if I bring back an employee that has a larger skill set and can cover more than one position? If our business is not back to pre-COVID sales, instead of bringing back someone that has only one skill set? Yes, you are allowed to do that. The only proviso I put on that is if you've got a unionized workplace and a collective agreement that applies, or if you've got something in your employment contract, you may be required to take back people based on seniority or various other things. But this is not an all or nothing for the public health leave or for layoffs. You can do them rolling. You can lay off some employees now and not lay off other employees. You can take back the ones that have the skill sets that you need. The only guideline in the layoffs is that you need to bring them back within 12 weeks. If you don't bring them back within the 12 weeks, then you're into common law. Then you're into severance and layoff, the regular stuff, and that's the issue. If we lay off an employee and they're eligible for EI, does that mean we do not have to pay them for the time of the layoff, either for a rolling period or the full 12 weeks? Do we continue to pay their benefits? You do not pay them. And as I just mentioned, you do not have an obligation to pay their benefits. Unless you've got something in your employment agreement that says, or in a collective agreement that says you are going to be required to pay the benefits at the time, then you're able to, then you do not have to continue their benefits. Like I said, I always give them the option of continuing the benefits on their own. You do not have to, no, you don't have to pay them for the time of the layoff either. This is a layoff without notice and without pay. Next one, if you're laying off employees or for the public health leave, put the ROE as illness injury, not shortage of work. If you put the ROE as illness injury because it is COVID related, then they avoid the wait time. They avoid the 1 week waiting time. If you code it any other way, government will still impose the 1 week waiting time. And as far as we know, although there was some talk initially about qualifying hours, the qualifying hours still do apply, which would be 600 in the last 52 weeks for illness or injury leave, and 700 in the last 52 weeks for approximately 700 in the last 52 weeks. It's coded based on the unemployment rate in Saskatchewan. So those still apply, but there have been some changes. Can you bring back employees on a part-time basis when they were originally full-time? This is where we start getting into some of the dicier areas. The answer is yes, you could bring them back. There is no restriction on bringing them back to part-time versus full-time. But once we get into part-time versus full-time, then you have to deal with what we call constructive dismissal. So if you've made a material change to somebody's employment status, they have a potential argument for constructive dismissal. The easy way to describe that is if I go out and buy a business next week and I say to my manager, I know you were making $90,000, but I am, because I'm cutting costs in buying this business, I'm only able to offer you a demoted position at $45,000. The manager would have no obligation to take that job, and they would have an argument against me for constructive dismissal. So that would be the one thing I'd flag if you're bringing people back on a part-time basis rather than full-time. that you're not breaching any of the layoff obligations, but they do have a potential argument at that point for constructive dismissal. I don't think it would come up, but I have to flag it for you. I mean, if you're bringing people back, good on you. I'm glad the business is able to bring the workers back. Now, if you're not able to bring some workers back or all of the workers back, then you are into a regular layoff and severance situation. That also applies if you decide, even during this temporary layoff period, that I'm not going to be able to bring these employees back. As soon as you make that decision, you need to trigger that, and you need to go ahead and go through the actual proper layoff and severance procedure. That's one of the considerations that you need to look at for the employees. Okay, I think that's all of the questions.
Hey, Steve, we have a bunch of questions in the Q&A panel here.
Okay. Let me just pull those up. Okay. Is the temporary layoff provision designed to dovetail with provincial and or federal programs for employees so they maintain income from a different source? Yes. So for those of you who are not familiar with them, the feds and the province have created some programs that do allow people to collect something, even if they're not eligible for EI. So there are some federal programs, including the removal of the wait time for EI, but there are two other. Let me just look here. The federal program, they've created what they call an emergency care benefit, and the emergency care benefit is where an ROE is coded as illness and injury, but the person would not otherwise qualify for EI. They are able to access that on a federal basis. That's not kicking in until April, and it's administered by CRA. We don't have very many details on it yet. There's also an emergency care benefit, which is that one is up to $900 every 2 weeks, if I remember right, and that one is for people who don't qualify for EI, and that includes self-employed. So that would include may include people who are not paying into EI, or self-employed contractors that are not that just do not qualify for EI. Sorry, that's the emergency support benefit. They've also, for your employees, and you can always tell them to look into this, they've added some one-time payments on the GST credit and the childcare benefit. I think as of right now, it's going to be administered in April, and it'll be paid out in May. That one is it's a one-time payment as far as we understand it right now, and it's a small increase in your GST check and your childcare benefit check for people that are eligible for that. There's also the moratoriums on certain things. The province has announced moratoriums or delays on payments for mortgages. Province and the feds have announced delays on payments for mortgages, utilities. There is taxes and tax filing dates. They've adjusted those, and generally without penalty. Now, they've worked with the banks to deal with deferring mortgages. I suspect the banks are still going to charge you interest if you defer your mortgage, but or defer any kind of a payment. The other question that's come up generally on this. The other question that's come up has been landlord-tenant stuff. Now, I'm not an expert in that, but I don't think the government's going to get involved in private contracts like that. So your best bet is to talk to your landlord or talk to your tenants if you're a landlord, and see what can be worked out to try and maintain continuity of income and business for everybody. That's the best option, the best answer I can give you there. Perhaps unrelated to EI layoffs, but curious if you'd heard anything about what degree of separation from a positive COVID contact would be required, would require an employee to be sent home as a precaution. As an example, if I come into contact with someone who was in contact with someone, thus being 2 degrees away. Well, if there's anybody in your workplace that has been in direct contact with somebody who has contracted COVID, then they should be in a 14-day quarantine. The 14-day quarantine doesn't just apply to travelers. Anybody who has been who has contracted COVID or has been in contact with somebody who's contracted COVID, that's the requirement for the for quarantine, and so that person should be in quarantine if they've come into contact with somebody. So that should not be happening in your workplace. And if it is, I'd be sending that person home right away. The other situation that's come up, and I've had this question a number of times now, so I might as well answer it before it comes up again, is what if somebody came back from international travel before these rules kicked in, but they'd still be in their 14-day period right now? I'd send them home for the duration of the 14-day period. That's what the law says now, is that you need to be at home for that 14-day period. But the reality is that some people did come home in earlier mid-March before the changes in the rules and the laws kicked in, and they did come into the workplace. I would, if they're still in their 14-day period, I'd send them home. And if anybody starts to exhibit any symptoms, I'd immediately send the entire workplace home. You need to make sure that you are observing the quarantine period. Okay, if we proceed with a temporary layoff, are we still able to top up in some form to support them financially? The answer on that one is yes, but you've got to be careful how you do it. You need to set up a plan with Service Canada. It's supplementary something plan that you need to set up with Service Canada. You can do it. You can do it for sickness benefits, and you can top them up to some extent. I think it's up to a maximum of either 90 or 95%. I haven't looked into it recently, but I know you can do it, but you have to set up the supplementary benefits plan through through Service Canada, so that they are aware of it and they do not try to claw back the EI from your employees. Look into it. If you've got questions on it, I'll try and send a link to the NSBA so that they can provide that information after this one. All right. For temporary layoffs, are there any guidelines regarding vacation pay? If requested to be paid out before the temporary layoff, does it delay their application for EI? No, it doesn't. So the position that we can take on this one is if somebody asks for their accrued vacation pay to be paid out, pay it out. If they don't, then keep accruing it. That's for businesses that are actually accruing vacation pay. For those of you who are paying out on every paycheck, this question really doesn't apply to you. But anybody who's accruing, you can pay out their vacation pay if you want to. If they request it, you're not obliged to at this point in time. And no, it should not delay their application for EI. Next one, if the government of Sask lifts the state of emergency, but business is slow, are we able to create employment contracts for returning employees, saying we may have to cut hours or provide further temporary layoffs, an employment contract that they would sign? Otherwise, business may have to provide permanent layoffs, which is tough on employees as they will lose years of work, and tough on businesses as they will potentially lose employees for the future. Good question. The overall answer is, if you are substantially changing the terms and conditions of employment, you need to make sure that both sides are contributing something. You need to make sure that that they are getting something in return for signing a new contract. So there has to be consideration for signing a new contract. And the courts are very skeptical of new contracts that reduce anything, whether that's wages, hours, duties. The courts are very skeptical, and that gets into the area that I was talking about earlier, constructive dismissal. So you can do it. There is some risk there in doing it. And you wouldn't be able to do it and create a new start of employment. So if you ended up having to lay them off, you would still be accounting for all of their past work. I realize that, and when we get to the end of the state of emergency, there's going to be a different set of questions that come up. And this is a good example of some of the ones that might be raised in the future. A lot of businesses are going to be looking at this option, and the answer is yes, you can do it, but you need to do it carefully. So I could talk about that topic for another hour, and maybe if the NSBA wants to have me back as we're getting to the end of the state of emergency, I can go through more of that. Okay. Does your employment agreement contract with the employees need to specify temporary layoff in order to use the new temporary layoff rules right now? No. You do not need to. I know that in Ontario, if you want to rely on their temporary layoff rules, you need to specify in the contract. The answer is no, not in Saskatchewan. That one is, that's an easy one to answer. Does your employment agreement, okay. Do you have to pay out all holiday pay at the start of the leave? I think I answered that one. No, you don't have to. If they ask for it, I would pay it out. But that one is, I think that was an answer that I already gave. You said to code the ROE for sickness, even if the temp layoff is due to shortage of work, to avoid the 1 week waiting period. Is that offside with EI rules? Don't we need to reflect it accurately as shortage of work? Well, in this case, yes, normally it would have to be a sickness case. We're in a different situation with the public state of emergency and the layoffs. So this layoff code, this temporary layoff that we're using, is based on COVID. It is based on an illness that has been declared to be a pandemic and has created a state of emergency in Saskatchewan. So it is not offside to code the ROE for sickness, even if the temp layoff is due to shortage of work. So the coding an ROE for illness injury is okay during this emergency period. Now, that doesn't mean that it's okay at any time to code it as illness injury, but this is an extreme case because of the public state of emergency and because of the nature of COVID. Has there been any more formal information on support for small business owners who are looking at an income shortage due to closures, because, but not because we are sick with COVID or in quarantine? Emergency support program versus emergency care program. There is let me make sure I get the name of it right. There is a temporary wage subsidy through the federal government. It is a limited amount. I think it maxes out at about $25,000 if I remember the details right. It applies to small businesses, so anybody who is eligible for the small business deduction, to charities and to not-for-profits. And that is a supplemental program that is designed to temporarily assist with wages. Other than that, it's mostly the deferred payments and the interest and penalty fee-free deferred payments that are being offered by the province and the feds. That's really what they've done. And I mean, the income shortage due to closure is a direct result of COVID. This is, even if you're not sick, or in quarantine. With COVID, the shortage of work is due to the global pandemic. So that's all they've really got for support right now. In addition to the temporary layoffs and the public health leave, which are both, although they're protected, they are without pay and without notice. So you're not required to give them notice, and you're not required to pay. If you have an employee that is pregnant and laid off and goes on EI now, well, that means she would not be entitled to a full 1-year EI maternity leave. No, that is a separate benefit. So that person will still qualify for their maternity leave, even if you implement this. This is a different situation. Once again, this is unique. This is a once in a lifetime type of occurrence with the public state of emergency. Even if you lay them off and they go on EI for illness injury right now based on COVID, if they're going on leave, maternity or parental leave starting in June, July, August, whenever they're going, they will still be eligible for the full 1 year or up to 18 months now of EI. It's same amount, but it can be spread over up to 18 months. Next one, if employees have COVID or are in quarantine, if they have run out of paid sick time, can we force them to use vacation pay before issuing ROE for EI? No, you can never force them to use vacation. It's one of the provisions in the Saskatchewan Employment Act says you cannot force employees to use vacation pay. They can request their vacation pay, their accrued vacation pay, if they have COVID or in quarantine, there are a lot of programs that can supplement their income, but you're not able to force them to use their vacation. What if someone one of their own choice on their own chooses not to come to work due to their current medical condition, not wanting to be exposed? What does the employer need to do? So this is one of the things that I was going to cover. I like how this has gone because I'm able to answer your questions, which is a much better format than just having me talk at you. One of the questions or one of the points that I was going to deal with as I went through this is refusals. So under our occupational health and safety laws in Saskatchewan, you are always able to refuse to perform unusually dangerous work. Now, what that normally means is work that you're not trained for and that is unusually dangerous for your job. Now, because we have identified that certain populations, notably the aging population and those with pre-existing conditions, are particularly susceptible to COVID, what employers are starting to see is, well, I don't want to come to work because of COVID. Now, the requirements that are put in place by the government, the self-isolating requirements and all of the other requirements are there for a reason. It's to prevent you from having somebody in your workplace with COVID. And with certain exceptions like the healthcare industry, the workplaces are designed to avoid having a COVID situation in your workplace. So if they are choosing not to come to work as a result of COVID, then I mean, I would work with them. Our recommendation is always have them work from home if it's at all possible. And if not, then maybe look at a temporary layoff. I know our government of Saskatchewan is phasing in their work from home program for all non-essential people it started yesterday, but they're phasing people into to working from home rather than working at the office wherever that's possible for non-essential employees, and they're continuing to pay. So that's one of the big issues that's come up, is that question of can an employer refuse to come into work? And that one, especially when you combine it with a workplace that had somebody come back for a few days to work before the rules went into effect about 14-day quarantine, and they're worried that that COVID was present in the workplace as a result of somebody coming back from travel and working for a few days before the rules came into effect. We're hearing that all the time. The precautions that are being taken are designed to keep COVID out of the workplace. Where it's possible, have your employees work from home. Where it's not possible, your grocery store settings, pharmacies, those types of businesses. In those cases, it's just not possible to have them work from home. And that is, I mean, it's one of those things that we deal with on a case-by-case basis. If they continue to refuse to work and you've told them, no, the workplace is safe, your next step is to get either your occupational health committee, or if you're a smaller workplace, your occupational health representative involved, and to tell the employee that it is not unusually dangerous to return to work. That's the way to deal with a continued refusal. And you've got to make sure you do that in writing. But if you've got questions about refusals, feel free to give me a call or email me after this. That's one of the common situations we're seeing. If you have an employee returning from mat leave as of Monday, do you have to do a temporary layoff? No, you don't have to do a temporary layoff. Assuming that the person is coming back and that you are not having them work from home, you do not have to do a temporary layoff with them. There's no obligation. These are options for employers, both the public health leave and the layoffs are options for employers. Now, what you might encounter with somebody returning from mat leave is they say, I'm sorry, I don't have childcare, and so I need to go home and care for my child. That is something you'd likely have to accommodate. Once again, that would be without pay, but you would likely have to accommodate that request. What if an employee? Yep.
Just so you know, this should probably be our last question because we're just running out of time here.
Okay. Let me look through these and see if there's one that really jumps into some big issues. For any of you that have questions, feel free to look at that website, at our website, and look at the all of the resources that we've created, that my firm has created over the last few days, which answers a lot of these questions that are coming up. Let's see. All right. What if an employee decided to work from home, no medical issues, but does not have enough work for full time? Does the employer have the right to lay them off? Well, the employee doesn't get to decide to work from home. The employer has the option to send them home. And if they send them home and authorize them to work from home, then you are required to pay them. If the employer sends them home either under the public health leave or under a layoff, no, you're not required to pay them. So the employee on their own deciding to work from home would definitely not be. I mean, you're technically looking at a potential resignation at that point if they're just saying, well, I'm working from home now. Now, we always recommend working with the employees and seeing what works for them and for the business, but the ultimate decision at the end of the day is the business's on whether to lay them off, whether to use the public health leave, whether to authorize them to work from home and to continue to pay them. So that if they decided to work from home on their own, that's unless you're dealing with a refusal situation, and I can answer one of the other ones at the same time, because there was a question about whether or not you have to pay refusing workers. You technically, while you're dealing with a refusal, if you don't pay them, you've got a potential discriminatory action complaint against you. And so, yes, you would continue to pay them. That is the incentive to get it resolved as quickly as possible, which in some cases may involve getting your occupational health committee or your occupational health representative. That's an internal person. That's not Occupational Health and Safety or WorkSafe Saskatchewan. That's an internal person in your workplace. Getting them involved and getting them to tell the employee, no, it is not unusually dangerous for you to report to work. That's generally a fairly safe analysis to do, especially with all the measures that we're taking. So, but while they're refusing, if you refuse to pay them at that point, or if you decline to pay them at that point, you're risking a potential OH&S complaint. So I know we're running out of time here, and I know there's still more questions on here. Hopefully I answered a lot of your questions. If you want to get a hold of me, you are able to do so. I think NSBA has got my contact information up on the website. If you want to email me directly, it's just steve@seiferlinglaw.com. Once again, the link that I saw that NSBA has posted has all of our COVID resources, as well as the changes to the law, the actual bills and orders in council that the government has passed. If you want to look at the actual wording of it, that's up on our website as well. There are some other resources I've seen that have come out that are phenomenal, and take the time to look around at the resources available and through the NSBA and otherwise that have been created by a bunch of people like me who are just concerned with hoping that everybody can get through this well. Thanks everybody for listening, and thanks to the NSBA for having me. I think this is being recorded, and so it should be available for anybody else if they've got questions, or if they just want to view it again. Yeah, thanks for listening to me, and I look forward to hearing from some of you. Andrew, anything else before we're done?
Awesome. On behalf of the NSBA, thanks a lot, Steve, and thanks everybody for attending. We will be getting the recording up as soon as we can.
All right. If anybody's got questions, feel free to email or call me. This is all I'm dealing with right now because the courts have shut down and everything else is shut down. So yeah, give me a call and I can help walk you through your individual questions, because every business is different. Thanks, everybody. I'm going to sign off now.